Morning, this is Rich Sierra. I'm the president of the Florida Small Business Legal Center. Thank you for listening today, whether it's morning or afternoon or evening. Very excited and very grateful that you're listening to our show, and hopefully you're getting great content to help you navigate the legal waters of small business ownership. This is episode number 43 of Business SOS, and as I always remind you, I want you to participate in the show. If you have a legal question that you'd like me to address, please send me an email at richsierra.com. And if I select your question and I'll address it in the show, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. A few episodes ago, I talked about mediation, and I talk about the importance of mediation, how it is a great vehicle to resolve legal disputes. And so today I'm going to talk about settlement agreements. And today's topic is important tips when drafting a settlement agreement. I believe settlement agreements are next to filing a lawsuit. It's really one of the most important documents that you can draft when the case has been settled and is often overlooked. People want to finish the case. People are in a hurry. They don't put the importance and the emphasis in making sure that all the details are included that were agreed upon in the settlement agreement and the various provisions that I believe should be included. Just a caveat, though. Today, I'm just going to give you kind of an overview of settlement agreements. It's not designed to be, to listen to this podcast and say, okay, I have everything that I need, so I'm going to go and draft a settlement agreement on my own. It is not the case. And in fact, I advise you not to do that. It's really, if somebody presents a settlement agreement to you, I want you to, at the very least, give you some tips and some pointers on what to look for. But I always advise, if you're in a legal dispute, get an attorney, which is the premise of my book, Business SOS. But also, if you're in a situation that a settlement agreement is drafted, it is worth having an attorney help you draft that agreement or review that agreement in order to make sure that all the provisions, number one, that what you agreed upon with the other party is included in the agreement clearly, but also that all the provisions necessary in that settlement agreement are included as well. So this is strictly an overview. So the tips that I will give you from the settlement agreement and release that I use in my cases. And unfortunately, I'm not going to be able to share this one with you. This is a very important document. It's my intellectual property. But at the same time, I don't want to have this document circulated and people make changes, and then it could be more problematic. But obviously, if I'm involved in your case, this is a document that I will utilize. One of the things that I look for in the settlement agreement has to be the recitals. Specifically, why is the settlement agreement drafted? It could be a situation that, in this particular case that I'm using, Joe filed a complaint for breach of contract against, ABC Company in Palm Beach County Court. The allegations are denied, and the other party filed the affirmative defenses and to the complaint. It's kind of a preamble what is the main basis of the dispute. It's simply kind of an introduction. The recitals are important because we talk about the reason why the settlement agreement has been entered into. The parties have negotiated a full resolution to the matter. That is very important to include that. Disputes, claims, potential claims arising between them and intend by the terms of the settlement agreement to memorialize the resolution of all the disputes. So it is very clearly in the agreement that this is going to be the final document that will govern the future relationship or whatever obligations there are within the agreement. I like to have provisions that the parties deny any no liability of any kind to the other party for any purpose, and deny that any defense is raised by the adverse party has merit, and that the agreement is solely and entirely made as a compromise and for the purpose of fully resolving the dispute of the disputed matters. It's basically, this is going to be the final document. And the reason it's important to do this is because you can have, there are lawsuits, especially in the business litigation context. Sometimes there are lawsuits that include fraud claims, they include all kinds of allegations, fraud and inducement, tortious interference. Sometimes you have civil theft, and the plaintiff could have a good case. And a question that I often, my clients ask me, after this, if I sign these documents, can I still pursue the lawsuit? And the answer is no. Okay, this will govern their future relationship. So it is important to know that once you have a settlement agreement in place, that's the end of it. So it is important to take the time to read the document, time to properly draft it, time to include all the provisions. And it's important that it has consideration, meaning one of the things that we write here is that in consideration of the recitals stated above, which all parties agree are accurate and complete, the agreements, promises, and warranties set forth below, and for other good, valuable consideration, receipt of which hereby acknowledged, the parties agree as follow. So their settlement agreements are contracts, and they're interpreted pursuant to contract law. And I'm talking here in the state of Florida, but I presume that also in those jurisdictions as well. So a contract has to have consideration. And a few episodes back, I talk about the elements of a contract. And in fact, in my book, I go into more detail about contract law and kind of an introduction for business owners that you need to be familiar with contract law because you'll be dealing with contracts through your entire business career. At least understand what a contract is and is not. So then you go into the part of what the obligations are within the contract. Okay, if you're the party who's going to pay, then you basically say, you will be paying a certain amount to the other party. If it's a lump sum, when will that be paid? If it's overpayments, when will that be paid? There's also a provision in most of these contracts that if you do not pay your obligation, you have a cure provision, 5 days notice to cure, or you do not have one. So those are important components as well. And what happens if you do not pay? Sometimes in some settlement agreements, they are what is called a hammer clause, meaning that if the party does not pay pursuant to the settlement agreement, there's an additional penalty. That's not a requirement for a settlement agreement, but sometimes they are included there. So I just want to make you aware of that. If it's something that you have to do, whether it's leave, transfer stock, leave a company, transfer property, that's all included there. Every obligation within the contract and the settlement must be included in the settlement agreement. Nothing must be left out. So it's important to, when you look at a draft of an agreement, review it and read it. And I tell my clients, you have to read your own contract. They send me the contracts to read. I'm happy to read them, but I'm assuming they read it as well. As a business owner, you have the obligation to your business to read your own contracts. And if you have questions, of course, bring the questions to your attorney. But don't send the agreement to your attorney and don't read it. And say, let me know what you think. That's fine. The attorney's reading the agreement from a legal perspective. You have to read it from your business perspective. But it's important that you read the agreement as well. Be familiar with it. If you have any questions in the agreement, let the attorney know. So go ahead and read the contract. And it's important that you understand what you're signing. And you know my rule, if you do not understand the contract, do not sign it. And again, that's what your attorney is there for, to clarify any questions that you may have and to assist you in making that decision. But we're here to help. Ultimately, you're the one who's going to live with this contract, not your attorney. So you have to read your settlement agreement. There are changes. The attorney will make them, send them out to the other side to make changes to it. But the process of drafting a settlement agreement is very important, and it should not be taken lightly. And I know sometimes people are in the haste of trying to get done with the case. They want to just move forward. Okay, looks good. Let me sign it and move on. No. Take your time to read it. An extra day is not going to make a difference, but it's important to read the contract, be familiar with it, understand its terms, and then if everything looks good, then you sign it. I like to have confidentiality clauses in my agreements, settlement agreements, that they're confidential. There's no need to have this agreement be displayed on the web, on a website, or anywhere else, or circulated. It is in a confidential settlement agreement for a reason. So it's a confidentiality clause there. There are exceptions to that. Obviously, you got an enforced settlement agreement. Most likely, the agreement has to be filed in court. Another clause that I like to include in my agreements is that each party, specifically the other side, had the opportunity to seek counsel and to, review the agreement with his or her attorney. And the reason I include that is because that way there's no, somebody says, okay, I really didn't have an attorney review it. It wasn't fair. You had your attorney. I want to invalidate the contract on the basis of unconscionability. And that is a different conversation altogether about the elements of how you can void a contract based on unconscionability. But let's call it, for the sake of this conversation, it just wasn't fair. You were in a superior position than me because you had your lawyer, he drafted it. I didn't know what I was reading. It is there. You had the opportunity to review it, seek counsel. If it's something regarding numbers, you can talk to your CPA. But it is there that they have opportunity to seek separate counsel to review the contract, and the attorney approved the contract. It is also important, I believe, to have the opportunity to a provision that says that the party signed the contract in his or her own judgment and belief and knowledge that they freely enter into this agreement. And the reason for that is to make sure that there, again, no issues as to there was undue influence in the signing of the contract, or fraud and inducement, or an unfair advantage. These provisions are there for a reason. And a provision that also I like to include is that, and I'm just going to read it because I think it's important, no provision in the settlement agreement is to be interpreted for or against of the parties because that party or its counsel drafted such provision. That is very important because in Florida, ambiguities are held against the drafter. So, in general terms. So there's a provision in the agreement that was not very clear. There's an ambiguity. And if you're the drafter of the document, the attorneys, usually one attorney takes the lead in preparing the first draft. That's usually the way it works. The other attorney says, send it to me, I'll take a look at it, I change it. So in this particular case, by including that clause, it said it's just as good as both parties contributed to the agreement regardless of who initiated the document. So if there's an ambiguity, it's not going to be held against anyone. That's why it's important to have clarity in contracts. Another provision that I like to include is called the merger clause. What a merger clause means is that if we had any type of understandings, oral, written, text, otherwise, before the signing of the agreement, that merges into this document and all that is gone. So that is very important to have that in there, that, everything we said beforehand is merges into this document. And you cannot say, well, you told me before I signed the document you were going to give me an extra $1,000. But that's not here, so you owe me $1,000. No. Whatever is in the agreement is the only obligation. Whatever we spoke beforehand merges into this document. That's what is called the merger clause. This is the document that will govern. You see how what I'm emphasizing here. Settlement agreements are very important. They should not be taken lightly, and it's the most important document that you will be signing if you settle a case. So it's important to take the time to read them. And if you have questions, ask the questions before signing. Don't rush. There are times that an agreement requires cooperation from the other party or from both. Whether they, for example, decide to sell a property as part of the settlement agreement or sign some documents in order to be able to complete a portion of the agreement. So this is what is called a further assurances clause. That if I need to, or just to give you an example also, you have to prepare taxes for the prior year and you need documents. So what it says is that, we're going to sign this agreement, but there's some things that we have to do in the future that if I request for you to sign a document if I request for you to provide me some financials to prepare the tax returns, you're going to cooperate, and that's part of the agreement. It's important to have in my agreements, I include that the agreement can only be changed in writing. And that is very important because sometimes people say, okay, we had this agreement, but I called him and said, okay, we can go ahead and make changes or to the payment schedule, or I don't have to do this type of obligation that I was supposed to do. No, that's not going to be binding in this case. Changes must be done in writing. The choice of law is also important. How, especially if you're dealing with parties from different states, which happens very often now that everybody's doing some more commerce in and out of the state and more transactions. So the choice of law is very important to say, if there's a dispute about this agreement, how are we going to resolve it? And which law is going to govern and which forum will be governed. This case could be, Florida law, and venue could be Palm Beach County, Florida. I also like to include that in the case there's a dispute, the prevailing party is entitled to seek attorney's fees from the non-prevailing party. So that way there's some type of provision that if you need to go to court to enforce it, you may be able to recover your attorney's fees. And as I mentioned to you before, just because you have that provision there doesn't mean that you will collect them automatically. It only means you're entitled to ask for them from the court. I'd like to include a non-disparagement clause as well, that the parties agree not to disparage each other. And again, this is not a requirement for settlement agreements. This is my preference, and that if the event that they're saying you have settled a case, that they don't start talking bad about each other and we may end up in court again. No, we're going to have a complete breakup. We're going to settle this case confidentially. We're not going to disparage each other. We're going to move on. The last but not least, the most important section in a settlement agreement are the releases. The mutual releases of liability. I like to include mutual releases. What that means is that when you settle the case, whatever the terms are, either you or the other party will not be able to sue each other for anything that might have happened in the past, including the circumstances or the events that led to this type of litigation. And this basically, in my agreements, it's a very, very long paragraph. But in essence, say from the beginning of time of the world to the date of execution of this release, which could have been raised and which will rise out of, relate, or in any way directly or indirectly involve the facts and circumstances of the action, except for any obligations or claims arising out of or from the performance of the settlement agreement. So what it means is that the release will release you and the other party from everything with the exceptions of the obligations in the settlement agreement. That does not mean that if tomorrow you do something or the other person does something, cannot be sued. It means up to the time of the settlement agreement. So it's very important that the settlement agreement only covers up to that point, nothing in the future, but also includes the obligations in the settlement agreement. Again, this is not a complete, and this is just to give you an idea of my settlement agreements. This is a 4-page document, and it's very comprehensive. Unfortunately, I cannot make it available. It's something that I use in my practice, and it's my intellectual property, but certainly, hopefully, that what we talked about today will be helpful to you. If you need to reach me, you can reach me at rich@richsierra.com. If you're interested in learning more about the legal services we offer in our practice, my website is floridasmallbusinesslegalcenter.com. Yeah, we're on Facebook at FSB Legal. If you want to reach me, my number is 866-842-5202. If you like the podcast, please appreciate a 5-star review and give us a review as well. Follow us. We also have this in YouTube at youtube.com/@RichardSierra. Remember to subscribe. Remember that Business SOS is 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.